Mr. Hobbs.
I'm called on. As you know, I appear with Mr. Reardon for the Microsoft Appellants. Mr. Hicks and Mr. Wildman appear for the Respondents, and Mr. Levy is here as the Greek chorus. I checked that. I could say that before we started. We set out a timetable at the back end of our reading guide. That's guiding us now, but we're, of course, as always and as ever, we're in your Lordship's hands as to what does and doesn't happen and how much depth there is. We've got a division of labour on my side. Mr. Reardon will deal with essentially the what's called PI1, which is the splitting issues, the use soft issues. He will deal with essentially that. I will deal essentially with the PI2 issues. There'll be a crossover, and I'm going to start with the PI2 issues because they actually embrace the totality of the case, whereas the PI issue is more limited in its scope.
Okay.
Right.
That's on the timetable, Mr. Hobbs. I know you asked for more time, but this appeal will finish tomorrow. Just in case there's any doubt.
I think I rather got that message.
Very good.
I watched a video recording of I think the last case my Lord did, which my Lord says is the length of time required to do the work, not the length of time to fill the available space, I think my Lord says. I'll be guided by that, but could you then please, in return to me, if I'm assuming you've pre-read something that you would want more information on, could you let me know? If on the other hand, I'm saying something that you've pre-read and you don't need more on it, could you also give me an indication on that? So it'll help me to be more focused in my submissions, I hope.
Yeah.
Right, let me start on what I always like to do, which is a pleasing note of unanimity. So if you were to turn up, please, the respondent skeleton argument, maybe you have it loose. It's in the core bundle, tab 10, and it starts at page 120. So the note of unanimity comes in via paragraph 26. The exhaustion doctrine in Article 4.2 of InfoSoc has been interpreted to be limited to sales of physical copies of a work, which may give rise to exhaustion under its Article 4.2, and then the keywords, not sales of intangible copies. This was first recognised in a case on copyright, and they cite Tom Cabinet. In fact, that's not quite correct. It'll go back earlier than that. Art and All Posters is the case in which the Grand Chamber in Tom Cabinet identified the law that they were about to apply. Now, it's not sales of intangible copies. There's no difference between us. The rule of exhaustion under Article 4.2 of InfoSoc is different in that respect from the rule under Article 4.2 for exhaustion in relation to the software directive. Now, they boldly say, it's bold from my perspective, in paragraph 27, the central question in PI2 is whether InfoSoc or software directive exhaustion regime applies to sales of software products that contain non-program elements. It's the or. This has been the constant theme of the case below. It is in fact the basis on which the judgment of the CAP was essentially founded. And just to reinforce what I've just said about it being the central theme, if you look at paragraph 40 of this document, the skeleton, I think you're going to find that it's echoed there. If my notes are not letting me down. Which of the two, first line in 40, which of the two directives? 42B, at the tailpiece of 42B, one or other directive. Para 55, which one? And paragraph 64 is premised on overlapping scope. So I do them no injustice when I say that this is what they're calling the central question. I'm going to be calling the central fallacy. The reason it's the central fallacy is because what you've seen discussed in our skeleton is, first of all, it assumes the correctness of the only basis upon which the judgment below and their arguments can be upheld. It presumes the correctness of their own case. More to the point, in relation to what are called in the language of the case law complex works, very key concept, complex works, the proposition is that you deal with them holistically, and the law provides the case law is all clear in one direction. I've been waiting to see if anybody can cite anything to the contrary, and it hasn't appeared yet. It's all for the proposition of cumulative and concurrent protection. And that needs a little bit of unpacking from me. It's cumulative in the sense that there may be a plurality of rights. So this is species of legal rights, a plurality of legal rights subsisting in relation to any given subject matter. And the cumulative and concurrent point runs also to the what you might call the segmentation dimension. So when you actually look at the thing itself, you will see that it's got constituents and components, some of which may go in one pigeonhole or bracket and other components of which may go in another. And that's particularly acute when you've got software as a part of a product. When I say software, I mean, of course, the code, because you've seen the case law which comes out of Sony Entertainment in particular. In the evolution of the protection, the argument about what the software directive so-called protects, the final denouement on what it does and doesn't protect comes from the Sony Entertainment case. It's been cited, you've got the quotations from it, it's very clear. Going back some time, Mr. Hicks and I were involved in the SAS case when it was in the Court of Appeal. There was still this notion lurking around that because it's called a literary work, that's what you classify a computer program as, it could get elbow room, it could get protection against non-literal copying. That was killed, stone dead, by the Sony Entertainment case. There is literal copying only, and it protects the code. It's either the source code or the object code. It protects the code only. It's a very limited form of protection. So I know we don't speak Latin so much as we used to anyway. It's a lex specialis, you've seen that. And it's sui generis, you've seen that too. It's lex specialis protection for a sui generis species of protection. Now,
would you say that followed a fortiori?
Well, it's res ipsa loquitur, isn't it? Right. Now, so let me tease this out with an example. You don't have to do copyright work for very long to know how this operates, but I'm going to give you an example which is going to be known to every copyright lawyer. So will you please hypothesize a Japanese author who wins the Nobel Prize for Literature? Will you please hypothesize next a gifted English translator who produces a perfect translation? Those works layer one on top of the other. Each of them has copyright. Now assume that there's a gifted playwright who turns the English translator's work into a play. He's got copyright. Now assume that someone decides there's a screenplay to be made out of this, writes the screenplay. Then assume they make the film. You have the set designers, the costume designers, the performers, and I've not even begun to talk about it being turned into a musical or a light opera yet. Now, the whole point is that it is axiomatic. It's been axiomatic since the very earliest days of copyright protection that you can't, by having clearance at one level or for one layer or for one component, you cannot get clearance without, not complete clearance, without getting clearance over all the other layers which subsist. It's holistic. This is what I mean by cumulative and concurrent. And it's a bit of a mouthful, but that's what I'm driving at. Now, the rule that goes with that is that you do not have dismemberment or excision. And I'm going to come to explain how that comes into the law. To get ahead of myself, the law that supports that view is the InfoPac case. We failed to bring enough authorities to court. That one's not in the bundle. But the InfoPac case establishes the proposition that you look at the work before you look at the parts. This is all essential to the understanding of the concurrent and cumulative protection thing. Now, what I'd like to do, what I want to do before I go too much further is to emphasize a point which I fear, suspect, am concerned may get lost if we don't focus on it. The word exhaustion is paraphrased. I could bring you 8 or 10 cases from the Court of Justice saying this exactly. It's paraphrased as extinction. So when exhaustion applies, it is the extinction of the right relative to which exhaustion has occurred. It operates by law, as it says, it extinguishes the right, and then please note this, there is no such thing as exhaustion of the reproduction right or the communication right. Now, to get well ahead of myself and possibly into my learned friend Mr. Reardon's submissions, one of the, I'm going to call it an oddity just for the sake of giving it a tag in my submissions, one of the oddities of the USOF case is that it involves an exercise of the reproduction right because of the downloading, and it involves that in circumstances where you very rapidly, if you don't keep an eye on it, create a situation in which there's exhaustion, forbidden exhaustion of the reproduction right when you're meant to be focusing solely on the distribution right. In short, the only right that is of any relevance to us is the distribution right under each of those directives. Now, I say, let me try and distill it into a question, which isn't going to be the question which is called the central question in 27 of my opponent's skeleton. Here's the question. I'll make the statement, and the question for the court is whether I'm right. You have Article 4.2 Software Directive, Article 4.2 InfoSoc Directive. We know, it's common ground, and we know anyway from our reading, they are different tests, and actually they're polar opposite tests. Now, my submission, and that's the question for the court, I think, is this. Neither as a matter of legislative interpretation presupposes or depends on the existence or absence of the other. Each has its own scope of application.
So on existence or
Absence of the other.
absence.
So I'll say it again, neither of them presupposes or depends on the existence or absence of the other. As a matter of legislative interpretation, each has its own scope of application. So the case actually is about legislative interpretation of those two provisions. And you've heard argument, as I understand, you've heard argument this morning relating to the way in which the claimant in this case relies on Article 4.2 of the Software Directive to carve out a market in circumstances where we say it won't do what they want it to do to create their market, in which all the other things come to be considered. Right, now, what I would like to do, and again, this is where I would say, stop.
When you say they neither presuppose or depend on each other, or their
the existence or absence of the other.
Yes.
Sorry, my lord.
Are you saying they're mutually exclusive?
No, I'm just saying it's all cumulative. Just like the protection is all cumulative and concurrent, these are cumulative and concurrent. One may apply, both may apply, neither may apply. But the question of whether they do or don't is determined by the legislative interpretation, which, as it happens at this point in time, is given to us by the two Grand Chamber decisions of the Court of Justice, Tom Cabinet being a Grand Chamber decision. Now, this is where I'm going to spend a bit of time looking at the legislation. I think.
I'm sorry, just to...
I'm sorry.
No. I mean, I probably used the word mutually exclusive wrongly, but the net effect is that if both apply, it may exclude the operation of one or the other.
Yes, but that's because both apply.
Yeah.
The premise leads to the conclusion.
Well, your preference is if they both apply, InfoSoc effectively governs.
Well, I get to that, and this is my opponents say we need to unpack it. That's the Nintendo case in particular. Nintendo is very important in the analysis here. I'm guessing. There are. I don't want to reduce my reliance on authority unnecessarily, but it's Art and All Posters, Nintendo, and Tom Cabinet, which, if you like, will constitute three main vertebrae for me. There's more. There's always more. But they will constitute the vertebra. Three of them anyway. Have I addressed at least for now?
Absolutely. No, that's absolutely fine.
We may get back to this as I go through some of this material. Right, so stop me if I'm taking you to material you don't need to see because you're already familiar or acquainted with it. May I just politely inquire I believe that some of your lordships are on hard copies of the authorities bundles, or, right, and others of you will be on electronic copies? Right, okay, well, I'll give tab numbers then because it helps those with, like me, with hard copy. Let me start with the
See,
software.
where some of us are physical, some of us are digital.
Well, it won't be long before I send an avatar over to make my submissions. Actually, I don't know why I'm laughing. It might be true. For all I know, there's a Ministry of Justice study on it right now.
Yep, let's hear it.
Right, okay. Now, in the authorities bundles, it'll be, if I go, I'm going to, it's slightly out of sequence, I'm going to start with the software directive, which is tab 3, which has page 18 in the electronic bundle, I hope. What is it? Oh no. Right, it's page 23, I'm told reliably. Okay. I'm going to pick up on a couple of points. First of all, the misnomer. This is not a software directive. This is, as it says, legal protection of computer programs. This is a computer program directive. There is only one use of the word software in the whole body of this document. And that can give rise to confusion of thought. You will please observe when you look at the CJEU judgments in this area, they religiously use the expression program and computer program. Why does it matter? It matters because of what I called the lex specialis and the sui generis protection being so narrowly drawn. This is literally within tram lines. Now, the misnomer I've identified, the paragraph in which the expression software is used is in recital 10, which you'll find on the next page. What's that, 24? Johnny, 24? Yes, recital 10. Then, forgive me, you go into Article 1, object of protection. That's been defined, now definitively defined by the Sony Entertainment case. It's the code. And they've teased that out. That limitation comes out of Article 1, little 2. The expression in any form of a computer program, and then you've got the familiar exception, the idea expression dichotomy. Please note from Article 1.1, because it matters for a submission I'm going to make shortly, Article 1.1 categorises, just as every developed nation has categorised computer programs as literary works. They are a species of literary works, albeit sui generis. You've got the provisions which deal with the restricted acts. 1A, 4.1a is the permanent or temporary reproduction. That's your basic reproduction right. You don't have a communication right in this directive, not singled out as such. At 4.1b, you have the translation, adaptation, arrangement right. And then at 4c, you have the distribution right. It is 4.1c, distribution right, that leads you into 4.2, which is what was construed in Usoft. This is the provision that was interpreted in Usoft. So 4.2 is the first sale in the community of a copy of a program by the right holder or with his consent shall exhaust the distribution right within the community of that copy, with the exception of the right to control further rental. So the rental right is not exhausted, but the distribution right in that copy is exhausted. And the whole of the debate, as between 4.2 of software and 4.2 of InfoSoc, is the difference between the language here about that copy and the expression used in 4.2 of InfoSoc, which is the object of protection. If you would turn, please, to Article 8, so it's your next page, what number is that? 27, 26, is it? 26. Article 8, continued application of other legal provisions. This is important. You will, I'm not aware of any legislative instrument coming from the EU in which there isn't a provision like this. Continued application of other legal provisions. The provisions of this directive shall be without prejudice to any other legal provisions, such as those concerning patent rights, trademarks, unfair competition, trade secrets, protection of semiconductor products. Please note, I'll come back to that. Or the law of contract. Now that's derogated from, in the next paragraph, any contractual provisions contrary to Article 6 of this, or to the exceptions provided for in 5.2 and 5.3 shall be null and void. Now that tailpiece on Article 8 nullifies only contractual provisions of the specified kind. The case law of the court, what's it called? Top system, which is in the bundle. The case law of the court recognises that it's not a complete oblivion of all the contractual arrangements that may apply to a transaction. The top system judgment recognises that the right holder can, by contract, regulate the modalities of the way in which things should be done, provided that the clauses in question do not, in fact, have the forbidden effect in the second part of this, Article 8. Now, I'm coming back to the protection of semiconductor products. For your note or for the transcript, the top system judgment is Authorities tab 31. What number is that? 772? 722, top system. And we've sidelined the relevant paragraphs. I'll come back to semiconductors in a minute. May I turn you back to the InfoSoc directive itself, which is behind tab 1. We've sidelined what we consider to be, between the parties, the material recitals for your purposes. I just want to single out a couple of them. So recital 15 tells you that this is implementing the WIPO copyright treaty. We abbreviate that to WCT, and I will take a moment or two to show you the provisions of that shortly. Would you notice, please, at recital 20, this directive, so that's InfoSoc, is based on principles and rules already laid down in the directives currently in force in this area. In particular, and 91.250 is the first incarnation of the software directive, the so-called software directive that I was just looking at. So 91.250 is what they carried forward with some minor modifications of no relevance. Then you've got, I think you've got the database directive and so on, several directives. It says, and it develops those principles and rules and places them in the context of the information society. Then this last sentence, the provisions of this directive should prejudice to the provisions of those directives unless otherwise provided in this directive. Now here's a key point for my case. The Tom Cabinet judgment has told us that this, via Article 4.2 InfoSoc, this does provide otherwise by comparison with the software directive. Because the rule, and it's common ground as I've just showed you, the rule is different in relation to InfoSoc works. So recital 20, last sentence, is telling you, essentially within the framework of InfoSoc, that you must give effect to the interpretation in Tom Cabinet. You can't set up a contrary regime for software code under the other directive. Now, recital 32 is important. This directive provides for an exhaustive enumeration of exceptions and limitations to the reproduction right and the right of communication to the public. Some exceptions or limitations only apply, etc. The list takes due account, etc., etc., etc. Now, the CAT has in fact created another exception By subsuming, I use its word, not that it needs to be chiselled in stone because you can see from what they did, it's the actuality of what they did. By subsuming InfoSoc protection into the ambit of a directive, namely the software directive, into which it does not fit, they have in fact created another exception by subjecting InfoSoc works to software directive exhaustion. That is quite simply a forbidden and impossible result. Now, I should have mentioned to you, yes, it's recital 9. I'm sorry I didn't mention it to you on page 5 at the top. This figures in the reasoning of the judgments on more than one occasion. You're going for a high level of protection for InfoSoc works. You're not going for desiccated protection, you're going for high level protection. Then may I take you to recital 60, which is on page 9 of the bundle. Protection provided under this directive should be without prejudice. It's the same formula that crops up again and again.
Sorry, remind me of the number again.
60, my lord, please. Page 9.
Yep.
Protection under this directive should be without prejudice to national or community legal provisions in other areas, such as industrial property, data protection, conditional access, access to public documents, and the rule of media exploitation chronology, which may affect the protection of copyright or related rights, but that's a precursor to a substantive provision I will get to momentarily. Now, I need to focus with you for a second or so on Article 2.
Sorry, does that include competition law?
None of these, right, okay. I'd like to
Recital
ask.
60.
I'm going to answer yes. Now, my lord will perhaps remember the excoriating experience of being involved in the tobacco and plain packaging and competition law IP interface. And I know it's an ever-present feature, competition law and IP law. My lord will know that I believe my lord will know that there are nuances on that interface. One nuance is you can have the intellectual property right in your back pocket. It doesn't matter because I'm going to apply competition law to your behaviour. There's a much more nuanced position, which is the property perspective. That is paraphrased in one of the generics cases in the CJU as the insuperable restriction. Inherent in the protection of property, and it's constitutionally protected, are certain restrictions associated and built into the exclusivity. That sometimes comes out as the doctrine of existence and exercise of rights. Although that has kind of faded and then it's come back again. It comes and goes. It's a bit like the Cheshire Cat's grin. But there is a slight nuance and differentiation. If you come at it from the property perspective, you will recognise that there are insuperable objections. Insuperable exclusivity restrictions that you must acknowledge at the IP competition interface. There are still some competition lawyers who say, well, never mind all that, it's all about behaviour. You can put the patent in your back pocket, it doesn't matter. I don't think that we, in all of our FRAN jurisprudence, for example, take that view. I think we are of the view that you do protection and that you look for balance. Maybe now isn't the time to go into this.
If you accept that in principle there may be some limit, well, recital 60 may include competition law. And of course it's implicit in the software directive, recital 17.
Yeah, absolutely.
Which is very particular. I suspect, where are we, 1990, it was just after the IBM settlement, well, 10 years off.
I haven't got that date clocked.
That was 1987-8, so the 1991.
Right.
That's what it's, anyway,
right. You're into the realm of software and competition law. Yes.
Anyway, but both accept that, at least in principle, there may be qualification imposed by competition. Where one strikes the balance is different.
Strikes the balance is the great conundrum, and it's pretty fact sensitive in case. But let me summarise how I, as an intellectual property lawyer, put the point. A well-founded claim for infringement is not, without more, a violation of competition law. A well-founded claim for infringement is not, without more, a violation of competition law. I'm conceding in the without more that there's other factors that may come into play.
Yeah. Doesn't really arise on for the appeal we're looking at in this
Not,
narrow sense.
no, but it's quite important to have it in mind, because you asked me the question, does this add to or detract from competition law? In principle it doesn't, but how it operates in the realm of competition law, another question. Now, I think I was going to take you to Article 2, which is on page 10. Now, this is for reasons which I will tease out a little bit later. This is I believe this is quite important. The scope of the reproduction right could not be broader. Member states shall provide for the exclusive right to authorise or prohibit, direct or indirect, temporary or permanent, reproduction by any means and in any form, in whole or in part. Now, that's as broad as you can get. This law even, which goes and says, cloud, yeah. In other words, this expanded definition of what the reproduction right shall comprise has itself been further expanded in the case law. And then the subparagraph is for authors of their works. It is an inherent feature of the EU legislation that, save in relation to, no, I'm stating too broadly. Suffice it to say, for authors of their works, there's no concatenation of what the works should or shouldn't be. A work is a work is a work, and then a part or the whole is another question. Now, the importance of the InfoSoc case was this, and this is why you see it mentioned repeatedly and notably in Nintendo. The importance of the InfoPack, my lord. InfoPack, yes. This was where they allowed for the possibility that 11 words might infringe on a press-cutting agency service. I'll give you the case. It's case C-5/08. And the constantly cited paragraphs are 36 to 39. I'm sorry to do this on the hoof. I think what I may do is ensure that you have a copy, because I think it may assume quite a degree of importance as we go on. Now, the point about this is, you look at the author's work, and you can straight away see that there's all sorts of things that may constitute a work, but you look at the work, and you ask whether the work is protected as being the result of the independent intellectual creation of the author. I'm paraphrasing the test, but that's the current test. You do the part protected by asking whether the part which has been taken partakes of the original character of the work. So when the claim was for infringement of the protection in the newspaper articles, which it was in InfoPack, you look to see whether the snippets, the 11 words, 20 words, or whatever that have been taken, whether they partake of the originality of the literary expression, being a segment of it. And that differs radically from what we would, well, I say radically, it's not the same as the test we used for Donkey's years, which was the whole or a substantial part with lots of judicial elaboration of what did or didn't constitute a substantial part. Now, InfoSoc is strong on the point that InfoPack is strong on InfoSoc about looking at the work and then seeing whether it's protected as a whole, or if you're looking at part, whether the part is protected. That's what I called a holistic exercise. We know that for authors of their works includes the authors of their complex works. And here's where the issue about the whole or part comes to be in need of careful consideration and analysis. In whole or in part of a complex work, bearing in mind the InfoPack test that was applied in Nintendo. Now, I'll leave it there for now, but you'll see an echo, or it will resonate with later submissions, I think. Article 4 is the distribution right. Now, Article 4, distribution right. First of all, Article 4.1, member states shall provide. Article 4.2. Please notice the orientation of this language. The distribution right shall not be exhausted within the community in respect of the originals or copy of the work. That's your rule, except where the first sale or other transfer of ownership in the community of that object is made by the right holder or with his consent. Now, we know from plentiful case law that exceptions relative to the rule are narrowly construed. The rule dominates, or the principle dominates in the first part of 4.2. And this is a key point, because in the interpretation of the exception that's written in 4.2, we know from Tom Cabinet in particular that you must give effect to the statements, the explanatory statements that were made in relation to the underlying WCT, WIPO Copyright Treaty provisions. And those provisions are explicit to the effect that it is only fixed, tangible copies of the work which can, the dissemination of which can give rise to exhaustion of distribution right under Article 4. We know that.
Which recital relates to Article 4.2?
Off the top of my head, I don't know. Mr. Reardon may say 28, isn't it?
28 and 29.
Yes, they are ordinarily in the case law read together. Oh yes, look, 28, the second and third line. And also the word that object in the community, which is about 5 lines into recital 28. And then it usually feeds you through to the tailpiece of 29.
And is that a statement of the only circumstances in which exhaustion can occur?
I'm going to answer yes, but this is not good enough for your purposes for that. You'll need this and more.
Yes.
I'm going to show you.
I mean, that's clearly an example of where there's exhaustion.
Yes.
The question is whether that's a definitive list.
You're not alone. Advocate General Spunner has made similar comments about this. It goes as far as it goes, but it leaves a bit of a loose end here and there. But you'll get the answer out of the WCT provisions, which I'll get to just as soon as I can. Right. Now, a point that is always made on scope is Article 1 of this directive on page 9. So Article 1 info stock on page 1 is that shall in no way affect, it's Article 1.2, shall in no way affect existing community provisions relating to the legal protection of computer programs. Well, it doesn't, provided that you respect the proposition that computer program directive applies to code, expressions of code. It doesn't, and you have to accept the corollary of that, which is that InfoSoc protects all non-program works, which qualify through authorship. Now, the bottom line on Article 4.2 is that there is no digital exhaustion of InfoSoc works. There simply isn't. Whereas the used soft decision allows for digital exhaustion, that's digital transmission resulting in exhaustion, under Article 4.2 of the other directive. Article 5 on page 10, it's got the exceptions and limitations. Suffice it to say, nobody in this case, the claimant in particular in this case, is not relying on any of the exceptions or limitations under Article 5. Its whole case for the market, which it says it's been excluded from improperly, its whole case for the market is under Article 4.2 of the other directive, the software directive. May I take you to page 12? I draw attention to Article 8, which is sanctions and remedies. And as we say in our skeleton, when you read the imperative language of Article 8.1, shall provide, etc., shall take all the measures to ensure, etc., etc., the member states are compelled to provide remedies for infringements and other invasions of InfoSoc protected rights. They're compelled to do it. Now, to get ahead of myself, it doesn't mean that there are no safety valves in relation to, what shall I call it, abusive or improper behaviour. But those safety valves are found at the remedies stage, because the enforcement directive is what provides, well, it's not the only one, it does provide attenuation, and the attenuation provided by the enforcement directive goes with the last sentence of 8.1. The sanctions shall be effective, proportionate and dissuasive. And when I put that up against Article 3.2, the general obligation in the enforcement directive, you'll see that the power at the remedy stage is to attenuate what would be the consequences to prevent undesired results. Which I'm putting it in that way elliptically for a reason, because I don't want to paraphrase what I'm going to show you. Now, Article 9 has got the other legal provisions. So here we go again. This is the commonest feature of everything, as I've said, in IP legislation. Without prejudice to the provisions concerning, in particular, patent rights, trademarks, design rights, utility models, and there's again, topographies of semiconductor products, typefaces, and I can go on, and go on, and go on, and then you look at the last bit, last 4 words, the law of contract.
And law of restrictive practices and unfair competition.
I think I'm just going to say yes. I mean, one would normally say that the law of competition is a public policy area, isn't it? Sorry, I don't want to ask you questions, but that's how you would look at it, I think. So, continued application of other legal provisions. I draw attention to the unqualified use of the expression the law of contract, because part of our complaint on this appeal is that the CAT simply declined to go into the interpretation and application of the properly interpreted provisions of the relevant agreements on the sample transactions, and it had no justification for not doing that, not least because the legislation says that you look at the contractual framework, and not least because the terms of the reference making an order for the PI trial said to determine by reference to however many sample transactions and their associated contractual provisions. It was actually built into the order for a PI trial. Mr. Wren will explain to you more about the contractual aspects of this shortly. Now, I'm going to go to the next, in mine it's tab 2, the enforcement directive. Right. I think probably it's a good idea to go to page 20 in the bundle to see the recitals we've sidelined. 32 on page 20. It is page 20, isn't it? Yes, page 20. Recital 32. Constitutional right of property. The EU Charter is robust. It says intellectual property shall be protected. It doesn't stop at the ECHR general wording about the protection of possessions. Shall be protected. Article 17 of that charter, 17.2 of that charter says that. Then look at these Article 2.2. It's without prejudice to the specific provisions of rights and on exceptions in, and that's both of those legislative instruments I've just been looking at with you. 91.250, as I've explained, was the software directive, so-called in its original form. and 2001/29 is InfoSoc. And I've already shown, and you'll notice the reference to Article 8, which I've said it compels protection. Now, the general obligation, this is all about remedies, but the general obligation you'll find on page 21. Article 3, 3.1 and 3.2. 3.1, Member States shall provide for the measures, procedures and remedies necessary to ensure the enforcement of the IP rights covered by this directive, which covers all of the copyrights and other rights we're concerned with. Those measures, procedures and remedies shall be fair and equitable, shall not be unnecessarily complicated or costly or entail unreasonable time limits. Fine. 3.2, those measures, procedures and remedies shall also be effective, proportionate, dissuasive, and here's the safety valve, as I called it, shall be applied in such a manner as to avoid the creation of barriers to legitimate trade and to provide for safeguards against their abuse. There's your safety valve. Is it protected? Yes. Has it been violated or infringed? Yes. What is it proportionate, etc., to do by way of remedy at the far end of that exercise? This cannot fail to be case specific and fact sensitive. It certainly cannot be what I think you will have seen from the case law as it's evolved in the Supreme Court. It certainly can't be the source of any ab ante rule to the effect that such and such a thing shall or shan't be forbidden intrinsically, inherently, or by its own very nature. This is an attenuated remedy. Now, I'm going to, because you've got the bundle and we're going through it, I'm going to slightly digress as I go through, but not too much, I hope. The EU Charter, just to remind you, on page 31 in the electronic, it's behind tab 4 in the physical bundle. Right to property. Now, what's new, as it were, relative to the Article 1, Protocol 1 of the JJH is Article 17.2. They were explicit from day one. Intellectual property shall be protected, mandatory. Page 32, Article 47 of the EU Charter, right to an effective remedy and to a fair trial. Well, self-explanatory. Importantly, is Article 52 on page 33. Scope of interpretation of rights and principles. Any limitation on the exercise of the rights and freedoms recognised by this Charter must be provided for by law and respect the essence of those rights and freedoms. Subject to the principle of proportionality, limitations may be made only if they're necessary and genuinely meet objectives of the general interest recognised by the Union or the need to protect the rights and freedoms of others. Provided for by law. It's been provided for by law. Article 4.2 of the InfoSoc Directive is provided for by law, and we have binding Grand Chamber interpretation of it through the Tom Cabinet case. That is the only extent of InfoSoc rights is, what shall I say, derogated from. At the same time as derogating from it, it specifies the limits of the derogation. What the CAT has done by subsuming, I'm using their own word and recognising that it's actually got other nuances throughout the judgment. What they've done by subsuming InfoSoc rights into software code, into the other directive, is that they've adopted a limitation on the exercise of rights which isn't in Article 4.2 and it isn't provided for by law by the legislation which does provide the distribution right exhaustion rule. Now, I've flagged up to you that both of those directives refer to topographies of semiconductors. Why do I want this? I could multiply many examples. My skeleton gives you examples from the case law. I can multiply many examples, but we can take out of the legislation itself in each of those instruments the reference to topographies of semiconductors.
Now, can I just come back to
yes,
the way you
yes.
put it? in particular when you say, you know, Article 4.2 is provided for by law. Your argument necessarily, I think, is, you may be right,
Yeah.
but involves the premise, if InfoSoc 4.2 prevails, then Software Directive 4.2 fails, and vice versa.
And so, yes, and so it should.
But you could apply everything you said to Software Directive 4.2. Value definitely provides exhaustion, it's clear, etc.
Yeah, I can live with that.
It dies if InfoSoc prevails.
And how do you do?
Balancing between the two then?
No, there's no. You've got the rule. This is
But
black
there's a similar
letter.
rule in 4.2 of the Software Directive.
Similar's not good enough.
Well, in fact, it's maybe said to be even more explicit than 4.2 of InfoSoc. But let's assume that's the same.
Let's not go on the nuances of the language. Let's stay focused. You have your tram lines
In both.
in both. So what's within the tram lines of the Software Directive? Sony Entertainment, the code. The code. It's limited to the code, and it doesn't protect against anything other than literal protection. That's it. Put that there. That's the rule when you're looking at code. InfoSoc. The rule is different. It's common ground. That's what I started with when I got up. It's the very first point. It's common ground. It's a different rule. Why is it a different rule? Because you cannot have digital exhaustion under InfoSoc, and that's the implementation of a treaty obligation. You cannot have digital exhaustion under InfoSoc. So I can answer perfectly squarely to my Lord's question, yeah, stay within the tram lines, but you get a different answer according to which set of tram lines you're in. And now, but that's why I gave you what I said I could ambitiously say to you is the legal question, which is the interpretation. Does the operation of either, I'm paraphrasing myself now, does the operation of either depend on the presence or absence of the other? The answer is no, it doesn't. Simply doesn't. It has to be put that way because of the architecture of the legislation and the way the pieces in the jigsaw fit together. There's no, in my submission, there's no other way.
It does come down, therefore, if you're right. Again, I'm not. This is not straightforward, but if you're right, then if there is 5% InfoSoc protected material in a product, then first licensing of that product doesn't exhaust. Or 1%.
I'm going to be. Well, no.
But how far does it go?
Well, I've just shown you. Sorry, I don't want to say anything. I've just shown you Article 3.2 of the Enforcement Directive. That's where the tension comes out, because the remedy cannot be disproportionate, and it cannot be so as to create artificial barriers to trade or be abusive. That is the point at which, if you're going to take into account small percentages here and there, that is the point at which you would take it into account. And you can perfectly well, I mean, I know my Lord Sir Colin Burse has been involved in many cases, and so have all the IP judges, on damages in lieu of injunction and that sort of thing. It's a very, very well-trodden path. And it always takes into account, by the way, competition law considerations at the interface. But I've said in my skeleton, and you'll forgive the boldness, the legislation doesn't fall to be interpreted by reference to outer extremity instances or examples. It's like construing patent claims. The judges are well versed in the proposition that just because you can imagine something that is really kind of like one side of the line or the other around the claim, that should somehow trip up the claim and bring down the patent. I mean, that's never been, anyway, care's been taken over that. Now, I'm going to come to this in more detail when I get to Nintendo, but please remember that complex works exist. There are more complex works in this world than there are soulless or simple works. So I've spent some time giving you the example of the Japanese Nobel Prize winner and so on and so forth. The world of IP, but particularly the world of copyright, is full of complex works. And therefore, the exercise that you're required to apply under one directive might locate or fasten upon a particular part of a complex work. And the other exercise you're required to apply under InfoSoc might attach to other parts of that work. Then what do? That's when I say you have to construe the legislation. That's when I gave you the question. Now, may I move? Oh,
Yeah,
no.
sorry,
No,
just
no.
following on, can you therefore say that it's Article 3.2 of the Enforcement Directive which strikes the balance?
Ultimately, it does, but there's
You thought that an enforcement measure should actually be the determining factor of where the balance lies. But I mean,
on remedy.
On remedy.
On remedy. But you see, we're debating the existence of the right, and that's why
Exactly.
I spoke in terms of extinction of the right.
Yeah.
On the case that's against me, they're not relying on any of the exceptions from protection. They're relying on extinction of the right. That's their whole case for their market. If it's not extinguished, then you're into the pathway that takes you down to the question of ending up on attenuation of the remedy under 3.2.
That assumes a valid right, but the remedy is moderated.
Yes.
So it's not really exhaustion, is it?
No, it's because there's no exhaustion that you're into the realm of looking at attenuation of the remedy. If you're exhausted, then you don't reach it.
Right.
You say there'd never be exhaustion.
Depends on what the...
No, it doesn't resolve. Your argument, as I understand, maybe I misunderstood your argument, but your argument is that for the case of the 1%, say, or whatever small number you like, small 0% of something which is InfoSoc rather than program directive, you say, don't worry, we can regulate all that at the remedy stage. With the enforcement directive.
Yes.
I get that.
You're required
I understand the point you're making, but that would still not be exhausted.
Don't like the extreme case because it's de minimis.
Well, you did it.
No. This is the exchange which is between me and the tribunal, which is recorded in the judgment below. I'm suffering post-traumatic distress.
All I'm reacting to is the submission that, if I may say so, you are making about the relevance of the enforcement directive.
Yes, in a world, remember, in a world of complex works. I didn't invent that expression. We live in a world of complex works. You pick up, if one picks up a book, if they're...
Sorry, just forgive me.
Yeah.
I do want to make sure I've understood what you say.
Yes.
What I thought you were saying, if I misunderstood, this is your chance to tell me, that in a complex work case, if you have a complex work which consists of some, to give them a label, InfoSoc works and some program works, there may be circumstances in which one takes the view that the enforcement directive means that relief would be given, which would essentially allow, as it were, the program directive to trump the InfoSoc directive. That's the point of your submission.
I don't like the word trump,
okay,
but...
Well, I don't mind, but I mean, that's how I understood it. But my question back to you is, I see what you mean, I think I understand it, but it wouldn't mean that there was exhaustion in that case, though. It might mean that the remedy isn't granted, but it wouldn't alter the legal character of what's taking place.
I'm going to answer yes to be simple, but, I'm not teasing, my lords. I'm going to answer yes to be simple, but we need to have Nintendo open in front of ourselves for this very point.
Okay, we'll get that.
And it's because, and that's why I dwelt on InfoPack, and I'm going to show it how it operates in Nintendo. I dealt on InfoPack because the question is, when you have a complex work, that's the whole work. The question then is, what protection might there be for part? And then the question is, does that part possess the character of the work as a whole? So there's a second level exercise when you're looking at part of something else.
Is it complex work or complex thing?
I don't mind, because I can see it in the case law. They're not, right, let me rewind. Anybody that's been brought up under the Copyright Act 1956 and the Copyright Act 1988 knows that we have got these compartments of works, artistic craftsmanship, etc., literary works, we've got all these pigeonholes. They don't do that in the Court of Justice. They use the Berne Convention concept of a work, that's Article 2 of the Berne Convention, and they say, is it a work? Is it the product of individual creative expression? Yes. Then you go on to the question of what happens to the parts of it at any later stage. But at the threshold stage, the question is whether it's a work. The main burden of my submissions is to say, please don't forget that we live in a world of complex works, and that I'm going to call them computer software products are complex works. Very much. Now, when it's put to me, well, there might be a small proportion, I say, well, yes, there might be. But it's not this case, and you have to deal with it.
You've got to be very careful. I mean, we have a finding of fact in the judgment about the InfoSoc content being ancillary, and there's a description of what that means. So that's way, way above your threshold for anything which is de minimis. We've got an issue around the 1%, 2%. Like my lord, I'm not certain that's answered by reference to the enforcement directive, which presupposes there is still a right to moderate. So the question comes back to, are you drawing any line at all? So even if there's a fraction, if there's a tiny bit of graphic work in an otherwise predominantly software-based product, you say there's no exhaustion of that tiny bit of graphic work, and therefore everything else remains non-exhausted. It's not unhelpful in our mind to test it at an extreme level.
Wow.
But you know, we may come. I mean, if you moderated that, you may come back to a concept of ancillariness, which is what the tribunal did.
Yes, but where do you? Sorry, I don't want to be impertinent by asking questions. Where do you find the word ancillary? It's not in this legislation. It doesn't say you're exhausted or not under InfoSoc, or you're exhausted or not.
It's their attempt to balance the two. You may say that's wrong in principle.
It is.
And therefore we do come back to, do you accept there is any line to be drawn between 0 and 100? I think that's about
between 0 and 100. Between 0 and 100. My lord, if it's a complex work, I'll answer, I'm not drawing that line.
Okay.
But please...
Complex work means what?
A mixture...
Any component of InfoSoc protected.
A complex work is a mixture of literary, artistic works, and do not forget that computer programs are categorized as literary works. Article 2.5 of the Berne Convention, you will see exactly how this comes to play through once you treat, as they do for juridical taxonomy purposes, a computer program as a literary work. You'll see how this plays through. But at this point in this debate, I'm going to say I'm not drawing that line by reference to any percentages at all. I'm saying, look at that legislation, that gives you a rule. National courts can't deviate, alter it, change it. Same for the other rule. Now the reconciliation, which is really what the case is about. And the reconciliation I gave you, what I understand, in my submission anyway, is the pivotal question of statutory legislative interpretation. A bit more to come. So you've seen that in the without prejudice to other rights provisions of InfoSoc and software directive, they both referred to, and I emphasised it when I was there, semiconductor topographies. Really good example as a litmus test. Because if you have a semiconductor and it's protected, you're going to have inseparably built into it program work. You may have diagram work. It may or may not be used in a way which produces visual output.
Topography, Mr. Holt. There's not a semiconductor, so
the product, the semiconductor product relative to which the topography protection is provided. It's a really good example of a, I call it a mixed work for the sake of convenience at the moment. Now, both
complex matter. That's what Tom Cabinet.
Yeah, complex matter. That's very good. That's what I'm talking about. So the semiconductor product is complex matter. And behind tab 5, you see the directive which preserves the exception to both directives without prejudice to. You see the legal protection of topographies of semiconductors behind tab 5. I'm going to try and take this reasonably quickly. On page 35 behind tab 5, we've sidelined a recital. The protection of topographies of semiconductor products, that's the key word, in accordance with this directive should be without prejudice to the application of some other forms of protection. So you see it yet again. in the substantive provisions on the definitions, which start in Article 1, then you've got, as usual, they define the definition in terms of itself. 118, a semiconductor product shall mean the final or intermediate form of any product, and then going on down as to what the characteristics of it may be as a product. And then B at the top of page 36, the topography of a semiconductor product shall mean a series of related images, however fixed or encoded, representing the three-dimensional pattern of the layers of which a semiconductor product is composed, and in which series each image has the pattern or part of the pattern of the surface of the semiconductor. Then commercial exploitation matters because it's the trigger for the exhaustion rule under this directive. Commercial exploitation means the sale, rental, leasing, or any other method of commercial distribution, or an offer for these purposes. So that's not even as narrowly written as 4.2 of software or 4.2 of InfoSoc. Commercial exploitation is extremely broad, including offer. Now, the exclusive rights are in Article 2, but I think I should take you to page 37. Article 5. The exclusive rights shall include rights to authorise or prohibit any of the following acts. And B is commercial exploitation, and I've shown you how broad that is, or the importation for that purpose of a topography or of a semiconductor product manufactured by using the topography. And then the exception, the exhaustion rule, is in 5.5. The exclusive rights to authorise or prohibit the act specified in paragraph 1b shall not apply to any such act committed after the topography or the semiconductor product has been put on the market in a member state by the person entitled to authorise its marketing or with his consent. So that's not the same rule as either of those other directives. And then look at...
So we're dealing with a complex product?
Yes, we are.
And the right is exhausted when it's put on the market?
Yes.
Regardless
on
of
the right in the topography.
Yeah.
Right, but I'm just about to show you Article 10 on page 38. Once again, continued application of other legal provisions. 10.2, the provisions of this directive shall be without prejudice to be the law of copyright in member states restricting the reproduction of drawing or other artistic representations of topographies by copying them in 2 dimensions. Now what you're seeing here, through the example given in both of the software directive and the InfoSoc directive, you're seeing how it works out in relation to a complex product, complex work I'll call it, but it is a complex thing, and how there is no way in which you can simply transpose the exhaustion rule from either of those other directives into the environment of this, because each of them is providing for their own legislative regime with their own rules for exhaustion.
There's an element of archaeology about all of this, isn't it? This is a 1986 directive.
Do you know, yes, and that's true of the software directive. This is the remarkable thing.
And the InfoSoc.
No, well,
that's over 20 years.
No, InfoSoc is written in a way that's intended to be dynamic, to keep abreast of technology. The software directive 91250, which lives on in the current incarnation of it, what is it?
2005, wasn't it?
No, 2009. 2009. Lives on in the same words. It has its origins all the way back in 91250. And the remarkable thing is that the WCT, the WIPO Copyright Treaty, had been enacted and all the member states were signed up to it, and nobody has taken it into account, or at least they didn't in USOF take it into account properly in relation to the software directive. But I'm just taking the example that comes out of without prejudice to other legal rights, the example of the semiconductors, and I'm saying that this demonstrates, it's an example which is given to us by the legislation, this demonstrates how in relation to complex works, call it a product, it doesn't matter, complex works, there is the stratification, which I've indicated, associated with cumulative and concurrent rights, and what's more, the way in which those elements of them may come to be dealt with according to the species of protection that they attract, is different and intended to be legislatively different. I need to show you, may I move on to, it's the Authorities Bundle Volume 3, it'll be tab 34, and I've lost it. Can you, no. I'm going to the Berne Convention. Can you call me the electronic bundle reference? It's tab 37, is it? Right, sorry.
Tab 37, yeah.
Tab 37, and what's the electronic bundle page, please? 837. Ah, yes, got it. Okay, so on 837, you can see the history. Origin September the 9th, 1886, various incarnations, table of contents, Article 2, protected works. Return to Article 2. This is a constant reference point on copyright in the Court of Justice case law. Article 2, page 840. Article 2.1 is a long concatenation of all the things that can constitute literary and artistic works, and it shall include, so I think I'm right in saying that the CJU has said it's not even exhaustive then. This is why the CJU has no trouble or difficulty in saying a complex work is one which comprises elements of the kind you see listed out in that concatenation in Article 2.1. But
does it include program?
Second,
Doesn't include computer program.
now I'm coming to that because that was introduced by the WCT, which is my next document. Right, now if you look at Article 2.5, that is cumulative and concurrent protection. That is it. Now, you may want to note on this, even if you don't, maybe I
Suppose
can.
this is about saying that a collection is a work of its own. Why is that anything to do with what you've been talking about?
Without prejudice to the constituent parts. That's the whole point about it. That's the whole work versus the parts of the work. So when you look at the whole work, and once you know, because I'm just about to show you that a computer program is a literary work for this purpose, once you know that that's how it's come to be treated, you can see how a software product becomes a collection of literary in the sense of code, literary in the sense of linguistic expressions, and artistic. It becomes a collection of all of those things. And the collection as such is protected without prejudice to the copyright in each of the works forming part. Now this, just as a historical note, this started out as Article 2 in the Berlin revision in 1908, but it was not quite so fully articulated. It came to be in this form in Brussels in 1948 and was carried forward in Paris in 1979 in the form that you're reading it there in 2.5.
And when in 2.5 it says it's an intellectual creation, does that mean it's a work?
Yes. And that's the only test. Now, after InfoPact, which permeates the whole of the EU, I don't want to call it revision, but the moderation of copyright, the only test for subsistence of copyright is that there should first of all be a work, and secondly, that the work that you're looking at should be the product of independent intellectual creation, the author's intellectual creation. A fortiori when you have a collection of works, a fortiori when you have a complex work. There isn't actually much difference between a complex work and a collection of works.
The computer's program isn't a collection of works. A computer program is not a collection of works. That's not why it has copyright.
No, that's not my case. That's not what I'm saying. A computer program.
A computer program doesn't have to be a collection of works at all.
No, it isn't.
So what's Article 2.5 got to do with it?
Because a computer.
This was why it had copyright protection.
Because a computer program, meaning as per Sony Entertainment, the code, the protected code, is a literary work. That is the taxonomy. It therefore becomes a literary work, and if you combine it in a software, I'm going to use the word product, complex work.
Okay, a product.
Yes, that's what I'm saying.
Okay.
So that's why I keep saying
when you were saying a program.
No. I'm sorry if I didn't express myself clearly. A complex work. I've just shown.
Complex work is an encyclopedia.
Not just.
Because it's got lots of different copyrights in it.
But not just.
The complex work doesn't have its own copyright necessarily.
The question whether it does is whether it's a product of intellectual creation.
Indeed.
And I'm sorry, but it is in this case.
Have you pleaded that?
I beg your pardon.
Have you pleaded that?
I'm not the claimant, I'm the defendant, as I think the point was made several times this morning. I'm the
You
defendant.
seem to have done most of the pleading on this issue, Mr. Hobbs, so
I
I
have,
maintain
yes.
my question.
Well, I've cited the case of Nintendo repeatedly, which in fact locates into this argument that I'm developing before you. Just a minute. So, I wanted to take you then to the WCT, and before doing so, I just wanted to remind you, yes, in the TFEU, which you'll find behind tab 39 on page 849, Article 216, the provisions of the WCT I'm about to show you are binding on all of the European Union institutions and on its member states. That's by virtue of Article 216. Now, this is in the TFEU. It has its origins in the Lisbon Treaty of 2009. It was carried forward. So since 2009, this has been the rule, that where the Union concludes an agreement at the international level, it binds downwards, besides which every one of the individual member states have signed up to the Copyright Treaty anyway. So, after perhaps too long of a run up to the crease, I'm going to take you to behind tab 45 in this bundle. Okay, remind me of that in a second. So behind tab 45 is the treaty. We've sidelined a number of provisions. Let me take you please to page 889. That tells you the relationship between this and the Berne Convention. And it's usually cited for Article 1.4. Contracting parties shall come Articles 1 to 21 and the appendix to the Berne Conventions. This is what's called, in terms of the Berne Convention itself, this is called a special agreement. There was some talk about whether they could do it by means of a protocol. They decided to make a special agreement, and this is it. Please look at footnote number 1, agreed statement. These statements are binding. The reproduction right, as set out in Article 9 of the Berne Convention, with exceptions, fully apply in the digital environment, in particular to the use of works in digital form. It's understood that the storage of a protected work in a digital form in an electronic medium constitutes a reproduction within the meaning of Article 9 of the Berne Convention. Now, this is the thing. I could show you textbooks from 1900 in which the authors would say the copyright consists of the right to multiply copies. Because of the way in which it's all evolved, so that storage and electronic transmission, including fleeting electronic transmission, constitutes reproduction, copyright has actually become, in the modern era that we live in, the right to control access to protected works. That's what it's actually become. Now, Article 4 tells you that computer programs are protected as literary works within the meaning of Article 2 of the Berne Convention. That is how I am able, when I showed you Article 2.5 of the Berne Convention, to say that the programs come in as literary works when they are part of complex works. That's how they come in. Then you have the right of distribution on page 891, which is Article 6. And I'm sure you're aware from your pre-reading that this is constantly cited, notably in Tom Cabinet. Right of distribution. Authors of literary and artistic work shall enjoy the exclusive right of authorising making available to the public through sale or other transfer of ownership. 2. Nothing in this treaty shall affect the freedom of contracting parties to determine the conditions, if any, under which the exhaustion of the right in paragraph 1 applies after the first sale or other transfer of ownership of the original or a copy of the work with the authorisation of the author. You don't need to worry, in my respectful submission, about the options that the legislators might have had available to them because they've exercised them. We have the directives. Then you have the famous agreed statements set out in footnote 5. Agreed statement concerning Articles 6 and 7 is used in these articles the expressions copies and originals and copies being subject to the right of distribution and the right of rental under the said articles refer exclusively to fixed copies that can be put into circulation as tangible objects. It is a treaty obligation, this is my submission, it's a treaty obligation that it must be, for exhaustion purposes, under Article 4.2, and this is what the court has said, Article 4.2 of the InfoSoc Directive, the dissemination of fixed copies, tangible objects. And this is nailed down, finally, whatever ambiguities there might have been, by the Tom Cabinet case. Now, given the exchanges that we've had a little while ago, a few minutes ago, I'm losing track of time, but shortly, a little while ago, if you took the language of this treaty, which is binding, Article 216 TFEU, is binding on all the institutions, if computer programs under Article 4 of it are literary works, then they are themselves within the scope of Article 6. And one of the great mysteries, I'm not going to weary you with any of the details of it, there was a host of critical reviewing after the USOF decision as to why they didn't accept the binding legal effect of the WIPO copyright treaty in USOF and say, okay, a program is a literary work and it's subject to this rule of exhaustion, but they didn't. Now, I can't turn the history back on that, but I can certainly say that when you come to Tom Cabinet, they went out of their way to make it clear that the exhaustion rule under 4.2 software was not the rule under 4.2 InfoSoc. What did you want to show me?
The answer to the pleading question.
What is it? Yes, the plea. So in terms of pleadings, I'm reminded by Mr. Reardon that the claimant itself pleads to copyright in software products. So the plea is set up as the copyright in software products, relative to which the exhaustion plea in paragraphs 20 and 21 of the particulars of claim under the software directive is said to. Is that in the particulars of claim or the reply? Particulars of claim. I was right. They speak in terms of products.
Okay.
And you've heard my submissions. Products are complex works. They should be speaking, and the questions were framed. The PI questions were framed in terms of the different species of protection, namely software directive protection and InfoSoc directive protection. That's how they were framed explicitly to be dealt with. But they themselves put it on the basis of products, and you've heard me on the subject of products being complex works. Right. I wanted to dispel the idea that I'm some kind of a heretic by running these arguments. I haven't got time to go into it, but you'll find the commentary, the legal commentary, proving or demonstrating that I'm not a heretic in this authorities bundle, in the fourth authorities bundle. It's behind tabs 55, 56 and 57. Now, I just can't afford to burn up time on going to it, but there is one thing I think I could show you, which is important, on page 1113, behind tab 56. Okay. Have they created? I don't know. Before there were ever any directives, the CJEU, page 1113, at the top, this is a parliamentary review, European Parliament review. In the case of Coditel, footnote 18, that's 1980, the CJEU laid down a principle that the community-wide exhaustion applied only to physical dissemination of copyright goods without extending it to intangible forms of commercial exploitation, such as a cross-border retransmission of a film. There has never been a time in which what are now categorised as InfoSoc works have ever been subject to digital exhaustion, always only physical. The outlier is the software directive as interpreted by the CJEU. Now, it means that when you see in the references in the judgment of the CAT to the Deutsche Grammophon case, the Deutsche Grammophon case has nothing to do with the price of eggs. That was about hard copies of phonograms. Coditel laid down the rule, which has been carried forward ever since, under the treaty provisions, before you get to the directives themselves, that there is no digital exhaustion of InfoSoc works. I think I need to go to the what I called it, the trilogy of the cases, the vertebrae. So I've got the horrible feeling that my note is going to be in the wrong place. So may I ask you to bear with me for 1 second? I'm looking for all posts, art and all posters. And in volume 2 of the authorities, tab 22, page 496, electronic. Art and all posters is the case which in Tom Cabinet, they themselves identify as where they first laid down the rule that there's no digital exhaustion of InfoSoc works. They say that themselves. I have to say that the people who were reading these judgments at the time did not understand it in quite such didactic terms, but this is where they locate the rule. So you see in the, if you're on 496, the first holding, the exhaustion of the distribution right applied to the tangible object into which a protected work or its copy was incorporated. And then they go on to a different question which was arising in that case. If I may take you to 498 simply to notice. For legal context on 498, they refer to the WIPO Copyright Treaty, particularly Article 6 of it. They refer to the Berne Convention. Every time they want to give an international context, the CJEU always goes back to the Berne Convention as iterated into EU law by the WC Treaty, the WIPO Copyright Treaty. 502, we've sidelined paragraph 30. This is Article 4.2 of the InfoSoc Directive. There is no option but to apply Article 4.2 to InfoSoc works. It is not an available option. The analysis, which is the one iterated subsequently, but actually not just iterated but amplified, the analysis is on page 503. May I ask you to read yourselves, please, paragraphs 34 to 40 on page 503.
Just on the facts of this case, we were dealing, I think, with a physical product simpliciter, were we not? I mean, paragraph 2 of the judgment refers to transfer of images of protected words from a poster to a painter's canvas.
Yes.
And the sale of those images.
Yes.
It wasn't a digital transfer.
No, it wasn't, and that's why I said to you,
It was a physical transfer.
it's the CJU who said that they, in Tom Cabinet, they've located their analysis in this. And I think I said a short while ago, it wasn't immediately apparent that it was that didactic to those of us who read it at the time. But there it is.
But just so we understand this case at this stage of your analysis.
Yes, but this is the rule. This is the analysis which is carried forward into Tom Cabinet.
Yeah.
And this is their reasoning on that rule. If you've read that
Just looking at paragraph 31.
I'm 31.
31 of the judgment.
Yes.
After the reference to Article 40 of InfoSoc. So taking the wording of the article as basis, court found that for the distribution to be exhausted, two conditions to be fulfilled. The original of a work or copy must have been placed on the market, in the European Union. So in context, we were talking about a physical product. I know we may transmogrify as it goes into
I know,
and so on.
I know. But then we're back to this old conundrum about when does the Court of Justice decide facts and when does it pronounce on the law.
I'm just trying to understand this
I'm
as a basis
agreeing.
for...
I am agreeing. Yeah. That's why I said it didn't look that didactic at the time. Yeah. It's didactic ex post facto.
Yeah.
Right, so on those paragraphs that run from 34 to 40, which I've asked you politely to have a look at yourselves, if I, may I just assume that you've just looked at them? And, no, all right, I'll just pause for a second.
I did anyway. You asked us a while ago.
I know. I just wanted to check whether all members of the court, I believe Lord Justice Green may just be looking at them now.
I was just, the one I alighted upon was 37 with the reference to the word that object.
Yes.
Is a reference to a tangible object.
Yes.
Not a digital object.
Precisely. And remember that's in the recitals anyway, because we looked at the recitals. It's recitals 28 and 29 of InfoSoc. Then you've got the copyright treaty, which they're saying bolsters all of that. You notice here that in 39 they treat the agreed statements on Articles 6 and 7 as binding. And then they say in 40 what the requirements are for exhaustion of the distribution right under InfoSoc. Right, so there you have our all posters. The first
Can I just ask about 39, the reference to the agreed statements? I think I would construe this as them using them as a guide to interpretation rather than binding. They don't say they're binding.
No, my lord, it's stronger than that. The Vienna Convention on the Interpretation of Treaties specifically says that you shall look at agreed statements when you're construing and interpreting the treaty provisions. It specifically says that, and we've got it in the bundle.
But looking at it to construe, that can be different to binding. A guide to interpretation is not necessarily binding. It may have powerful effect, but it may not be the same.
I beg to differ respectfully. What you're seeing here is the first of a number of cases. I could cite many others, but you'll see it again in Tom Cabinet. It's not just informative. It's not just educational. It kind of means what it says. That's my submission as to what the status of those statements is, and that's consistent with the Vienna Convention. The Vienna Convention in EU case law is that the status of it is it states, I think, what they call customary international law, and customary international law is binding on the CJEU. That's the perspective, but I don't think I need to go there, given that what they've said here and what I'm about to show you shortly when we get to it in Tom Cabinet. So that's the first of my three vertebrae. I'm now looking for Nintendo tab 21, am I? Yeah, Nintendo tab 21. Yeah, probably. Now, that's tab 21, and I would like to show you, please, what Advocate General Sharpston said, because I'm seeing it echoed in the judgment of the court. So, to get to what Advocate General Sharpston said, her opinion is, I'm fumbling for it for a moment, yes. It begins in the bundle on 479. Now, the case was about technological measures for protection, and it arose, the issue that she's discussing and which the court had to address was this: which directive are you looking at for the purposes of the technological measures protection? Because they're not exactly the same between the software directive and the InfoSoc directive. Each of them has technological measures protection, but the InfoSoc technological measures protection is more comprehensive, Article 6 InfoSoc. So the taxonomy, you have to work out which directive you're under. On page 483, she notes in AG5 at the top, self-explanatory, she it is who, in a passage I'm coming to, uses the expression complex work, meaning the whole thing.
In AG5?
No, I'm going to get to the complex work. She's using complex work to refer to the whole thing, as I shall show you. Right, so I pointed out that the question was, which directive are we under, says the court to itself. Page 488, she's got the heading Relevance of Directive 2009-24, Software Directive. Relevance. It's clear from the order for reference the National Court has made certain findings of fact and concluded, contrary to the argument put forward by PC Box, those games are not to be regarded as computer programs within the meaning of software directive, but as complex multiple multimedia works falling within the scope of InfoSoc. In its written observations, Poland suggests that these findings might be queried, although its own not entirely conclusive analysis seems to lead it in the same direction. The court therefore asked the parties attending the hearing to address the question of the applicability of InfoSoc in circumstances such as those of the main proceedings. Nintendo and the Commission agreed with the approach taken by the National Court. PC Box, on the other hand, contended that it's the software directive, not InfoSoc directive, which was relevant in the circumstances at issue. She says in 33, this court's got no reason and no competence to reassess. In 34, software directive concerns only computer programs, whereas InfoSoc concerns copyright and related rights in intellectual works in general. So we're talking about the lex specialis and the lex generalis. The latter leaves intact and in no way affects existing EU provisions relating to inter alia the legal protection of programs. The court has thus stated that the software directive constitutes a lex specialis in relation to the provisions of the InfoSoc directive, and she's citing used soft. In my view, that statement must be read as meaning that the provisions of the software directive take precedence over those of the InfoSoc directive, but only where the protected material falls entirely within the scope of the former. If Nintendo and Nintendo licensed games were computer programs and no more, software directive would therefore apply, displacing InfoSoc. Indeed, if Nintendo applied separate technological measures to protect the computer programs and the other material, software directive could apply to the former and Directive 2001 InfoSoc to the latter. However, the National Court has found that Nintendo and Nintendo licensed games cannot be reduced to the status of computer programs alone. They include also intellectual works in narrative and graphic form which appear to be inextricable from the programs themselves. Nintendo's measures affect access to and use of the games as a whole, passing down about 4 lines. Where complex intellectual works comprising both computer programs and other material are concerned, and where the two cannot be separated, it seems to me that the greater and not the lesser protection should be accorded. If that were not so, right holders would not receive, in respect of that other material, the degree of protection to which they're entitled under the InfoSoc directive. So she's dealing with the whole question of complex works which have components, some of which is under the program software directive, and the other rest of it is under the InfoSoc directive. And there's no question here of percentages, one way or another. You look at the work, it's a complex work, and then you look at the parts, and when you look at the parts, you take them as you find them. That's what she's saying. Now, in the judgment of the court, so may I take you, you're still behind the same tab. I should start you at 474, para 19. I don't need to dwell on 19 or 20, just to show you that it's the frame of reference for the questions. And then paragraph 21. First of all, it must be noted that InfoSoc concerns, as is apparent from Article 1.1 thereof, the legal protection of copyright and related rights, including for authors, exclusive rights to their works. As for works such as computer programs, they are protected by copyright, provided that they are original, that is, that they are the author's own intellectual creation. And they cite InfoPack, the case that's always cited on qualifying for protection by virtue of independent intellectual creation. And you'll notice that they are not referring there to the software directive. 22. As regards the parts of a work, it should be borne in mind that there is nothing in Directive 2001/29 indicating that those parts are to be treated any differently from the work as a whole. It follows that they are protected by copyright, since as such they share the originality of the whole work. And they cite themselves paragraph 38 in InfoPack. That is why I spent time saying that paragraphs 37 to 39 of InfoPack do say exactly what is being said here. You look at the whole and then you decide whether any given part of the whole work benefits from the protection of the whole. That's what InfoPack says. And then in 23, this is the reference to software directive, that finding is not weakened by the fact that Directive 2009/24 constitutes a lex specialis, CU soft. In accordance with Article 1.1 thereof, the protection offered by software directive is limited to computer programs. That's my tramlines point. As is apparent from the order for reference, video games such as those at issue in the main proceedings constitute complex matter, so they're using the Advocate General's terminology, comprising not only a computer program but also graphic and sound elements, which, although encrypted in computer language, have a unique creative value which cannot be reduced to that encryption. Insofar as the parts of a video game in this case the graphic and sound elements are part of its originality. They are protected together with the entire work by copyright in the context of the system established by the InfoSoc directive. That is my point about looking at the work before you look at the parts, treating it holistically and looking at it without dismemberment or excision at that stage. You may find, you may not find, but you may find that it's necessary at some later stage after that to go to the question of whether a part, how a part of it is to be treated. But they are plainly, in my respectful submission, accepting the stance adopted by the Advocate General, which is you cannot reduce the InfoSoc works to the status of program works, even though they are encrypted or may be encrypted. They are part of the originality of the complex work, and they are protected together with the entire work.
The entire work in that is the video game.
Yes. The complex work, the video game, the product. Yes. This is why I've been urging you to accept in my submissions that you look at the work as a whole before you go into the questions of its constituent parts. This is why I've been labouring the whole concept of cumulative and concurrent protection and what it means. This is the reason I've been submitting from the very beginning that concurrent and cumulative protection relates to separate species of copyright legal protection and may also involve separate component parts of an otherwise complex whole.
Can I ask you this?
Yes.
If, let's twist the facts into something which is probably artificial. If in a very, very old-fashioned way, Microsoft put its entire product onto a hard disk and handed it to the customer, who was then downloaded it and redistributed in the ordinary way, on your analysis there would be exhaustion because it had been sold in a physical way as opposed to being digitally transferred.
Yes, that's clear. That's very clear. That's clear. What the CJU, the Grand Chamber in USOF, did was to analogize the download to doing that by proxy, so to speak. That, from where I'm standing, is a false step, but we're not going back to that. I'm living in a Tom Cabinet world. Can I take you to Tom Cabinet? I'm very, very conscious.
Is it necessary? Is it a necessary part of the analysis to decide in the context of Nintendo, as they did in Nintendo, that the video game is itself a work?
Is it necessary?
That's what they do. As I understand it, what this is about, it isn't taking the individual images, let's say, the individual bits, and all the individual programs or any of those things. It's saying there is another copyright, which is in the video game itself, which is composed of the programs and the code and the pictures and everything else. Is that a necessary part of the analysis?
Yes, because the question confronting the court, as I said, is which of the technological measures protection provisions is applicable. You would apply the software directive ones if they were applicable. You would apply the InfoSoc ones if the InfoSoc ones were applicable. You had to choose which it was.
The reason I asked that is that if I remember right, you put General Sharpston right, and you showed us this, he contemplates the possibility that they might have applied different measures to the different parts.
Yes.
That doesn't work if you do it this way.
Well, that's what the court said.
I understand, but you said they were following Advocate General Sharpston.
They are
what
following.
She says is that you can have technical measures for the program bits and technical measures for the other bits. She wasn't. I don't think she was. She saying what's said there?
On the technological measures, no. But on the question of the taxonomy, she says what they said, which is that you put them all within the InfoSoc directive. The totality goes into the InfoSoc directive.
Okay. She says you give the greater protection.
You say, my lord, you say greater protection?
Yes.
I think she put it the other way around. You wouldn't be, if you did otherwise, you wouldn't be giving the protection that you're entitled to under the InfoSoc directive. I think that's the way she put it. In other words, if you're going to round in either direction, you round up, not round down. So that's page
Paragraph
488.
35, isn't it?
It's paragraph 35 on 488 at the bottom. Where complex intellectual works comprising both and where the two cannot be separated, it seems to me that the greater and not the lesser protection should be accorded. If that were not so, right holders wouldn't receive the protection they're entitled to. And I pointed out that that's guaranteed under the, that's guaranteed under the EU Charter. Right, I'm getting severely into injury time on the division of labour between myself and Mr. Reardon, but I absolutely must deal with the third vertebra, which is Tom Cabinet. If I can find it.
Tab 28.
Tab 28 is the very one. So behind tab 28, which is electronically starting on page 615, I think I've got to, through pressure of time, I've got to skip over the headnote material, sorry. Suffice it to note, page 620, they're using the phraseology of complex matter. Now, I'm not going to, the Advocate General was extensive in this case and influential, but I think I must at this point stick with the judgment of the Grand Chamber. If I remember correctly, yes, the presiding judge on the court was Judge Lennertz. Judge Lennertz this was the Grand Chamber. They assembled, you can infer that they assembled the Grand Chamber because they were discussing InfoSoft relative to UseSoft. Judge Lennertz, I believe, was the juge rapporteur on the Grand Chamber in UseSoft. There's no way in which, as it were, he could have participated in these deliberations without remembering his own before. So page 643, just to note, the international law. They're citing the World Copyright, the WIPO Copyright Treaty, paragraphs 4, 5 and 6. 6 brings in the agreed statements and 7 quotes them. Moving into the body of the judgment, may I take you to page 651. Paragraph 38 is familiar. The approach to interpretation, halfway down that paragraph after the reference to Whiteman, EU legislation must, moreover, so far as possible, be interpreted in a manner that is consistent with international law, in particular where its provisions are intended specifically to give effect to an international agreement. To which I would go further and say Article 216 TFEU tells you, leaves you with no real alternative but to do that. Paragraph 39 tells you that the InfoSoc directive implements WCT obligations, in particular communication to the public and distribution to the public. Paragraph 40, Article 6.1 defines the right of distribution as the exclusive right of authors to authorise the making available to the public of original copies of their works through sale or other transfer of ownership. It is apparent from the wording of the agreed statements, and they quote them, and therefore that Article 6.1 cannot cover the distribution of intangible works, such as e-books. Looking to 41, because they refer back to it, so 652, the explanatory memorandum for the InfoSoc directive is in line with that statement. They quote it. Paragraph 42, in the second place, the European Commission also stated in the explanatory memorandum in the proposal for the InfoSoc directive that proposal gave an opportunity to provide for a coherent level playing field for the electronic and tangible distribution of protected material, and then the key words, and to draw a clear line between them. In that context, the Commission noted that an interactive on-demand transmission was a new form of exploitation. I don't think I need to dwell on that particularly. Paragraph 44. Still in the explanatory memorandum, the Commission added that the expression communication to the public of a work covers acts of interactive on-demand and so on. Last 4 lines in 44, while making clear that that right covers any communication other than the distribution of physical copies, since physical copies which can be put into circulation as tangible objects are covered by the distribution right. It thus follows from that explanatory memorandum that the intention underlying the proposal for the directive was that any communication to the public of a work other than the distribution of physical copies of the work should be covered not by the concept of distribution to the public, Article 4.1, but by that of communication to the public within Article 3.1. Then you get to the paragraphs on page 653, which in my respectful submission nail this point, well, the point. Paragraph 51 refers to recitals 28 and 29. You'll see the words we looked at incorporated in a tangible article. 52. In the 4th place, an interpretation of the distribution right referred to in 4.1 of InfoSoc as applying only to the distribution of works incorporated in a material medium follows equally from Article 4.2 of that directive as interpreted by the court in relation to exhaustion of that right. The court having ruled that the EU legislature, by using the terms tangible article and that object in recital 28, wished to give authors control over the initial marketing in the European Union of each tangible object incorporating their intellectual creation. And they locate their jurisprudence in Art and All Posters in the paragraphs that I've shown you. Then you get 53. Admittedly, as the referring court notes, the Court of Justice has ruled in relation to the exhaustion of the right of distribution of copies of computer programs mentioned in the software directive that it does not appear from that provision that exhaustion is limited to copies of computer programs on a material medium, but that on the contrary, that provision, by referring without further specification to the sale of a copy of a program, makes no distinction according to the tangible or intangible form of the copy in question, see USoft. However, as the referring court correctly points out, an e-book is not a computer program and it's not appropriate to apply the specific provisions of 2009-24. And then 55. Paragraph 55 was quoted verbatim in the judgment of the CAT at paragraph 57. In that regard, first, as the court expressly stated in USoft, which constitutes a lex specialis, the relevant provisions of the software directive make abundantly clear the intention of the EU legislature to assimilate, for the purposes of the protection laid down by that directive, tangible and intangible copies of computer programs, so that the exhaustion of the distribution right under that directive concerns all such copies. 56 was omitted from the judgment, from the quotations in the CAT, but it's crucial. Such assimilation of tangible and intangible copies of works protected for the purposes of the relevant provisions of the InfoSoc directive was not, however, desired by the EU legislature when it adopted that directive. As has been recalled at 42 of the present judgment, it's apparent from the travaux préparatoire for that directive that a clear distinction was sought between the electronic and tangible distribution of protected material. 57 was cited by the CAT, quoted in paragraph 58 of the CAT judgment. Secondly, the court noted at 61 of USoft that from an economic point of view, the sale of a computer program on a material medium and the sale of a computer program by downloading through the internet are similar, since the online transmission method is the functional equivalent of the supply of a material medium. Accordingly, interpreting Article 4.2 of the software directive in the light of the principle of equal treatment justifies the two methods of transmission. Now, paragraph 58 is crucial relative to that. It was omitted from the paragraphs quoted in the judgment of the CAT. The supply of a book on a material medium and the supply of a book cannot, however, be considered equivalent from an economic and functional point of view. As the Advocate General noted in his opinion, dematerialised digital copies, unlike books on a material medium, do not deteriorate with use, and used copies are therefore perfect substitutes for new copies. In addition, exchanging such copies requires neither additional effort nor additional cost, so that a parallel second-hand market would be likely to affect the interests of the copyright holders in obtaining appropriate reward, contrary to the objective referred to at 48 of the present judgment. Then you get paragraph 59, which the CAT did quote. It quoted it in paragraph 59 of its own decision. This is the paragraph which introduces the word incidental. Even if an e-book were to be considered complex matter, see to that effect Nintendo, comprising both a protected work and a computer program eligible for protection under Directive 2009-24, it would have to be concluded that such a program is only incidental in relation to the work contained in such a book. As the Advocate General noted, the e-book is protected because of its content, which must be considered the essential element. Now, we picked up, and the CAT didn't like it, that we picked up at it on our skeleton, that the language in the other language versions of the judgment, that's the official language versions of the judgment, use the expression accessory rather than incidental, accessory to or incidental. The language of the court being French, that was the wording they used. But now look at the words even if. Even if. It is, in my respectful submission, impossible to understand that paragraph 59 is resigning from, qualifying, altering, watering down or placing a condition on the antithesis which has just been spelled out in paragraphs 55 and 56 above. It's impossible. That antithesis is drawn on the basis of the legislative intent and the wording of the legislation, and it is plain where they're coming out. The words even if mean it makes no difference if. It's not a ruling about video games. The rulings are being made in relation to the interpretation of the legislation. It makes no difference if an e-book were to be considered as complex matter, and they explain why they would say that.
I mean, there's some odd language here. I get the use of the word even if. So even if an e-book were considered complex, then you've got it would have to be concluded that such a program is only incidental.
Yeah, accessory.
Incidental
or accessory, yeah.
Or accessory.
Yeah.
Have to be concluded. Is that they're not? There's nothing which goes. It would have to be concluded for such is only incident for such and such a consequence to occur, which isn't there.
I know. Well, that adds to the even if.
It could be even if blah blah blah. Our conclusion is that such a program is only incidental. That might be another way of putting it.
Well, in English terms, you'd call it over the dicta. But
I don't think they know that concept.
They don't. No, they don't speak.
It's not that difficult to understand, though, is it, Mr. Hobbs? I mean, the point they're making is that if you were to consider the e-book as complex matter, the same decision would be reached in relation to the issue they're deciding, because in the case of an e-book, the program is only incidental and therefore doesn't govern what you're going to do. That's what they mean, isn't it?
Well,
or accessory. I don't care. It doesn't matter whether it's accessory.
No, I'm not going to quibble over accessory and incidental too much. I didn't like incidental because it's hierarchical. Accessory means auxiliary, supportive, goes along with. But if you look at it as a complex work, it fits the analysis in Nintendo. If you apply the analysis in Nintendo to complex works, you look at the whole, then you look at... That's
not what they're doing, is it, Mr.
No, but why refer to Nintendo at all?
Right.
The Advocate General, I noticed, didn't even mention Nintendo in his opinion. Right. Even if, well, you have my submission. It's not possible, it's coherent to suppose that 59 is stating a limitation or a qualification or doing anything other than affirming the rules that they've stated on interpretation at 55 and 56, which are didactic. Those rules are didactic.
The second part of 59, which refers back to AG 67,
Yeah.
seems to, I mean, if you were going to introduce a qualitative element, you'd ask what was the essential element. And paragraph 67 of the Advocate General's opinion rejects a submission that an e-book constitutes a computer program. It's not a computer program because really it's its content, and all the computer elements is to enable it to work. If that's what, and isn't that what they're endorsing in the second part of 59? The essential element is the book, the software is ancillary or secondary or accessory, whatever, and it enables it to work.
I'm still going to say that that's done in the transition from the rules as interpreted in 55 and 56 and turning to the case that was before them on the e-book, and they're analogizing across, I suppose, to complex matter and Nintendo. Well, I'm not going to keep wearying you by saying the same thing except to say it one last time. You cannot suppose that the rules set out in 55 and 56 are being altered by anything in 59.
But I think there's an intermediate stage. 55 and 56 are pretty stark. And then they say, oops, look what we did in used soft. And I see that Lennox was in used soft, but he wasn't the presider, it was Kouris.
I wasn't right.
But doesn't.
No, I know.
So they've then got to grapple with conflict with the judgment in used soft. And is really 56 through to 59 a sort of a softening of the start position in 55 and 56? That's the issue.
I respectfully disagree, my lord. The whole thing they had to decide was whether the rule, which you find for exhaustion in 4.2 of InfoSoc, allows digital exhaustion.
Yeah.
It doesn't. And I pointed out emphatically more than once, as I've been standing here, that it doesn't. It simply doesn't. That's the legislation. And as I heard Mr. Andrew Morritt once say to the House of Lords, that's the law and it's not my fault. So clear-cut distinctions?
Mr. Hobbs, I reckon every single case I've ever heard you in, you have said that.
All I can do is congratulate my lord on his memory, or congratulate myself on the force of my submissions. Some things stick in your mind.
You certainly do.
Do you mind? So I think, did I hear my Lord Justice Green say stark, or how did you put it? Between
stark.
50?
I mean, you know, if you want your the strongest position you get to is 55, 56.
Yes.
And then they're going, oh, blank. What do we say? Use soft. Do we have to mitigate our rule to take account of that?
I don't mean
and that. All I'm posing a question as to what they might be saying. I haven't for a moment got my head around whether that's right or not.
They don't mean that, and they can't mean that, and because they've just told you in 55 and 56, is it 55 and 56? I think it is. They've just told you in 55 and 56, the legislature did intend in the software directive, and the legislature did not intend in the InfoSoc directive. Well, if it didn't intend in the InfoSoc directive, and they're saying so, and they're ruling accordingly, that should be the end of it.
Isn't it? I mean, it's not that complicated. What they do in 54, 55, 56 is say an e-book's not a computer program, so the software directive doesn't matter. What matters is InfoSoc, and InfoSoc wins, and it's tangible only. And then they say, well, if you're going to treat it, we're going to look at USOF. The best you could get to, if you're trying to argue the contrary, would to treat it as complex matter, but the software in the computer program in the complex matter is only accessory, and that's not good enough.
You've heard my argument. Whether you use the word accessory or not, all I'm saying is that the work as a whole, bearing in mind that the program is a literary work, and I've shown you Article 2.5 of the Berne Convention, I've spoken about the whole product, the whole work. I can't go back over it again, but my arguments, I think you'll find when you look back at the transcript, to support me when I get to Tom Cabinet. my Lord Justice Green used the expression stark. We've got stark. I'm really running out of time. I'm going to be shot, and if I survive the first shooting, I'll be shot again. Can I take you to page 672 in the bundle behind tab 30? It's really quick. I say really quick, minutes. This is a case, when was it? 2020, I think it was within less than a year of Tom Cabinet, yeah, yes it was, less than a year. And all four members of the court, except the president in this one, BYCX, sat on the Grand Chamber judgment in Tom Cabinet. Right, so what happened was, somebody sent a photograph by email, attached to an email, to a court for use as evidence. And the person who had the copyright in the photograph said, "You can't do that. That's my copyright." Now, I know the instinctive reaction of common lawyers to that sort of proposition doesn't bear repetition, but anyway, that's the case. So page 679, the Advocate General, AG 20. It's not in dispute that the photograph was sent electronically by email to the court hearing the dispute between the parties in the form of an electronic copy. Page 680, paragraph 32. Not necessary to answer the first question. It's clear from paragraph 3 and 6 of the request for a preliminary ruling that the protected photograph, which is the subject of the proceedings before the referring court, was sent by email as evidence to the civil court in the use of the proceedings before them. Pursuant to Article 3.1 of the InfoSoc Directive, authors have the exclusive right to authorise or prohibit any communication to the public of their works, etc. Moreover, 4 lines, 5 lines in, Article 4.1 of that directive provides that authors have, in respect of the original of their works or of copies thereof, the exclusive right to authorise or prohibit any form of distribution to the public by sale or otherwise. 4.2 InfoSoc further provides that this right is exhausted where the first sale or other transfer of ownership in the EU of the original or of a copy of the work is made by the right holder or with his or her consent. It's clear from Tom Cabinet, that's the case he cites in 34, that in order for there to be a distribution to the public pursuant to 4.1 of InfoSoc, the work must be put into circulation as physical copies, material items or tangible objects. That particular requirement of Article 4.1 of Directive 2001/29 is not met when transmitting a work in intangible form by email, he says. Now suppose that my client's products had been, they haven't been and they wouldn't be, but suppose they'd been transmitted to the first purchaser by email as attachments to emails. Just suppose that. All of these words would read straight on. Transmission by email is not distribution. That's what he said, and the court dealt with it in equally short shrift on 689 to 690, all stark. 689, paragraph 19. So they note, photograph sent to the court in the form of an electronic copy. 20, it follows from the case law that the communication to the public of a work, other than distribution of physical copies of that work, does not fall within the concept of distribution to the public referred to in 4.1 of Directive 2001/29. It goes to communication to the public. Tom Cabinet is cited, and then in 21, the view must be taken that by its question, which is appropriate to examine together, the National Court asks, in essence, whether Article 3.1 must be interpreted as meaning and so on and so forth. It's as stark as can be. If, when, and because it is not sold, sent, transmitted in anything other than physical form, the Article 4.2 rule InfoSoc does not apply. There's no digital exhaustion. Right. As as I said, I'm really struggling for time. I know your lordships are concerned about time. Are your lordships perhaps willing to sit to 4:30, or is your preference for 4:50?
Just a minute. I think I'm going to have a problem, Mr. Hobbs, I'm afraid.
I understand.
My colleagues. No, I can't sit till 4:30, I'm afraid. I'm very sorry.
Right. At this point, all I can do in self-defence is to say, you have my skeleton, you have my submissions in there, and I'm not abandoning any of them, because there's going to come a point in which I simply can't gabble them out in all submissions.
All right.
I've got to give way to Mr. Riordan, and if you're rising now, he's going to be the next voice you hear.
That's fine.
Might you sit at 10 o'clock in the morning or 10:15?
I'll do that tomorrow, I'm afraid.
Okay, sorry. I'm sorry, I don't want to be a burden of my
I don't think
asking.
you're pertinent, Mr. Hobbs, it's just not possible.
There you go.
I will see you at 10:30.
Rise, people.